like to talk about the constitutional remedies. This is the sixth group, or rather when you broadly classify our fundamental rights. I talked about right to equality, then right to liberty, right against exploitation, right to religion, fifth one, right to the minorities or the cultural and educational rights, and finally there is one more, that is the right to property, that has been removed. Otherwise it would have been 7 groups of fundamental rights, now 6 groups of fundamental rights, and the sixth and the last one is the right to constitutional remedies. Right to constitutional remedies. This is Article 32. So, in this chapter, let me first talk about Article 32. Then I will be talking about the public interest litigation also, various dimensions of the writs also, difference between Article 32 and 226, I will be talking it separately. So, there are multiple angles to be talked about. So, in this particular video, I will be specifically talking about the various aspects of Article 32. So, Article 32, in fact, according to Dr. Ambedkar, it is the very soul of the Constitution and the very heart of it. He said it is the very soul and the very heart of the Constitution. The heart and soul of the Constitution, Ambedkar said. If there are no remedy, see, in fact, this is the remedies make the fundamental rights real. The remedies make the fundamental rights real. And if there is no remedy, there is no right. If there is no remedy, then don't talk about a right, then there is no right. The rights and remedies, or without remedies we cannot talk about a right. If there is a mechanism to enforce, if there is no mechanism to enforce your right, then the very the claim that you have so many rights is meaningless. So that is why it is the heart and soul of the Constitution. If you cannot enforce your fundamental rights, there is no meaning in talking about fundamental rights. So 32 gives the real life, the real soul and the power to the fundamental rights. If 32 is not there, a list of rights have no meaning, because whenever your rights are violated by the state, you should be able to go to the court, and the court should ensure your fundamental rights. That is very important in any democracy, because there is always a chance of violating your rights. So coming to Article 32 and 32(1), it says that the remedies for the enforcement of rights conferred by this part, it says the right to move the Supreme Court. Article 32(1) says the right to move the Supreme Court. The right to move the Supreme Court by appropriate proceedings for the enforcement of the fundamental rights. Right to move the Supreme Court for the enforcement of fundamental rights, for the enforcement of fundamental rights. So, the right to move the Supreme Court for the enforcement of fundamental rights by the fundamental rights conferred by the Constitution is guaranteed. 32(1) says it is guaranteed. So, your guarantee, your right to move the Supreme Court for the enforcement of the fundamental rights is guaranteed according to Article 32(1). So, the right, now the question is, who can move the Supreme Court? The meaning of Article 32, right from 32(1), right from the beginning, was that any person, any citizen whose rights are violated, okay, any citizen whose rights are violated can move the Supreme Court. So that is the understanding, that was the understanding right from the beginning. Anybody whose rights are violated, he can, on behalf of him, an advocate will move. So, he can approach the Supreme Court. But over a period of time, Supreme Court realized that in India, because of the poverty, because of the illiteracy, because of lack of awareness, a vast majority of the people may not be able to approach the Supreme Court for fulfilling, for enforcing their rights. So, over a period of time, in the working of the Indian Constitution, Supreme Court realized that a vast majority of citizens, because of their poverty, because of their illiteracy, because of their lack of awareness, because of they being discriminated. There is a lot of discrimination in the country because of their discriminated. Because of they being discriminated, they may not be able to they may not be able to move to the Supreme Court for fulfilling or enforcing their fundamental rights. So, Supreme Court relaxed this provision. So, Supreme Court said that on behalf of these people, these poor people, these people whose rights are violated, on behalf of these people whose rights are violated, any public spirited citizen can move the Supreme Court. Any public spirited citizen can move the Supreme Court. See, very important. See, earlier only those individuals whose fundamental rights are infringed can approach the Supreme Court. Earlier position by the Supreme Court was that only those people whose rights are violated can come to the Supreme Court. But over a period of time, Supreme Court realized that there are so many sections of a vast majority of the Indian population who are either very poor or illiterate or totally unaware about our rights. They are discriminated. They don't have even the capacity to even fight for their rights. They may not move the Supreme Court. They have no capacity to move the Supreme Court. They are not even aware that there is a Supreme Court. So, Supreme Court said that on behalf of these people whose rights are violated, especially these poor people, the illiterate people, any public spirited citizen can move the Supreme Court. So, it is this any public spirited citizen can move the Supreme Court, and that is how under Article 32(1), we have the public interest litigation. So, Supreme Court subsequently incorporated the concept of public interest litigation. Public interest litigation. So, this is a very dynamic approach. Supreme Court has moved away from that static one, now a very dynamic approach. It said that any public spirited citizen can approach the Supreme Court. And the concept of PIL started in India late 1970s and early 1980s. Almost 30 years, 80s, 90s, almost 40 years have gone now. 40 years of public interest litigation in India right now. Public interest litigations are possible because of the liberal interpretation by the Supreme Court. I will come to that separately, but this is how Article 32(1) provides for public interest litigation also. So, Article 32(1) says that the right of a citizen, it is very clear, the right to move the Supreme Court for the enforcement of the fundamental rights is guaranteed. Now, even a public spirited citizens can also move on behalf of those people whose rights are violated. That is Article 32(1). Coming to Article 32(2), it says the Supreme Court shall have the power to issue directions or orders or writs. Supreme Court can have the power to issue directions or orders or writs. See, the word writ has come from the Roman law. The word writ is not an English term. it has come from a Roman law. It is from the Roman law, but it has developed in the English system. Okay, English law it has developed, but it originally came from the Roman law. There are, see, Supreme Court have the power to issue directions. Writ means order or direction. There are 5 different writs under Article 32(2), including the writ of habeas corpus. I will be talking about this separately to protect the liberty of the people. Then mandamus, then prohibition. I will be talking about separately, that is why I am not explaining this. Then certiorari. Certiorari and quo warranto. So, these are the means and mechanism, these are the directions or orders or the writs through which Supreme Court will enforce the rights of the people. How the Supreme Court can issue the, how the Supreme Court can enforce your rights or protect your rights? By issuing writs. There are 5 types of writs. I will be talking about that separately. So, that is Article 32(2). 32(2). So 32(1) says any citizen whose rights are violated can approach the Supreme Court. And 32(2) says how the Supreme Court will enforce your rights or protect your rights by way of issuing writs. Now, coming to Article 32(3). Article 32(3). 3 says without any prejudice to the powers conferred on the Supreme Court. That means it is already conferred to the Supreme Court, but Parliament may by law, very interesting. 32(3) says Parliament may by law, that means it can move a law, it is pass a law, empowering any other court, empowering any other court. So, Parliament may by law can empower any other court to exercise within their jurisdiction or within their local limits, within their local limits, all or of the entire, all the powers exercisable by the Supreme Court under this Article 32(2). So, within their local limits, the what you call geographic limits, all or any of these powers exercised by Article 32(2). So, Parliament may by law can empower any other court to exercise within their local limits the powers mentioned under Article 32(2). So, whatever powers, what is the power? The power to issue writs. So, Parliament by law can entrust this responsibility, can empower any other court to exercise this power within their jurisdiction, the local limit, the power to issue writs. So, Parliament may by law can empower any other court also to issue writs. Very interesting, which is given the writs or the power which is given under Article 32(2) of the Indian Constitution. But till now Parliament has not done that. But in the Constitution it is very clearly mentioned, Article 32(3) says Parliament can empower, may by law can empower any other court, to exercise within their local limit this jurisdiction of Article 32(2). So, any other court also can issue writ if the Parliament empowers it by law. But Parliament has not done anything till now, so there is no problem, but that option is always there. Article 32(3) says that. Then finally, Article 32(4), a fourth one, Article 32(4), it says the right guaranteed under this article shall not be suspended except as otherwise provided by the Constitution. So, this Article 32 cannot be suspended. That means an executive order or any other ordinary law cannot suspend this right to constitutional remedies. Right to constitutional remedies. So, whatever rights are provided under Article 32(4) cannot be suspended unless otherwise provided by this constitution, except as otherwise provided for by this constitution, otherwise provided for by this constitution. So, 32(4) says these rights, the right guaranteed under this article, that means the right to constitutional remedies cannot be suspended except as otherwise provided for by the, see, constitution has provided there is emergency powers, fundamental rights can be suspended. So, Article 32 will not be available when for those fundamental rights which are suspended. See, when during national emergency under Article 352, if fundamental rights are suspended, then for those fundamental rights which are suspended, Article 32 also will not be available. So, it is very clearly mentioned. So, what is the meaning of this? The meaning is our right to constitutional remedies cannot be suspended by an executive order, cannot be suspended by an ordinary law. It can be suspended only by an amendment of the constitution, or it can be amended, or it can be suspended only by using the provisions of this constitution. So, 32(1), all citizens can approach Supreme Court if their fundamental rights are violated. 32(2) says that whatever, how the Supreme Court will enforce your fundamental right? By issuing writs, 5 writs, it talked about 32(2). 32(3), it says the Parliament may by law entrust any other court to issue writs under Article 32(2), but Parliament has not done it till now. And 32(4) says that the rights guaranteed, that means the right to constitutional remedies guaranteed under Article 32 cannot be suspended unless otherwise it is provided in this constitution itself. The meaning is through an executive order, or through an ordinary law, Article 32 cannot be suspended. There has to be a constitutional provision for suspending Article 32. Yes, there is a provision for suspending Article 32, that is through Article 352, the national emergency. When national emergency is in force, according to Article 358, Article 19 is automatically suspended. And then it is said, Article 359, I will be talking, I have already talked about that, I am repeating. President through a separate proclamation can suspend any other fundamental right except 20 and 21. 20 and 21 cannot be suspended. All other fundamental rights can be suspended. And Article 30 is available only for 20 and 21 during that time, or only for those fundamental rights which are not suspended. So, 32 also can be partially suspended. I have talked about this already. So, how the suspension of fundamental rights topic I have already talked. That is what I am repeating. So, 32(4) clearly mentions about that. So, Article 32 has 32(1), 32(2), 32(3) and 32(4). These are the provisions of Article 32. Now, in another video I will be talking about this, how Supreme Court will protect our fundamental rights by issuing writs, and I will be explaining those writs separately. So, that will be in another video.